I may be allowed to call an affidavit, Lordship, in item number 8 for my withdrawal of
Okay.
Okalo. I fail.
You have filed it?
Lordship on Saturday, Lordship, I filed.
Okay.
May it please, Your Lordship. But there's an order 41 hearing matter, my lord. It was fixed last Friday. But when the matter was called up, my lord, I was on next in different court, for which, my lord, the matter was fixed after 2 weeks. No date was given, my lord. So, my lord, my appearance is, my lord, the date may be given. Order 41.
I can't do it now. Which matter?
My lord,
It's in the list.
Hello?
It's in the list.
Friday's list, man.
I can't do it. The matter is not there before me today. And if you have to mention, you have to mention it before, I think Justice Phukan.
Highly okay.
And for a duel.
Your name?
P. Sharma. P. Sharma.
P. Sharma.
Yes, Lordship.
Mr. P. Sharma, the learned counsel appearing on behalf of the appellant, submits that he has instructions to withdraw the instant application. Because taking into account the above, the instant application stands closed on withdrawal. Interim orders, if any, stands vacated.
Item 9 fixed at 2 p.m.
Yes, what is,
My lord,
what are you challenging here?
my lord, the order dated 2/3/2021 passed by the first appellate court, my lord. My lord,
Hmm?
the order is at page 96, my lord.
Yes, why are you challenging?
My lord, the petitioner had filed a suit, my lord, for permanent injunction, my lord. She is a tenant in a shop premises, which was declared to be illegal by the GMC. Now, my lord, the petitioner was a tenant since the year 1983. My lord, now they've sent a notification under section 337, my lord, that the premises is illegal and they have directed it to be demolished. Now, my lord, to that effect, the suit was filed and another application under order 39 rule 1 and 2 was also filed, my lord, which was allowed. Against that, my lord, the defendants number 1 to 5 have preferred this appeal, my lord, misappeal, bearing number. My lord, in the misappeal, my lord, the first order was passed. The impugned order is the first order, wherein, my lord, the injunction was stayed, my lord. My lord, the entire case of the petitioner is for injunction, my lord. If that is, my lord, stayed, my lord, and if GMC, if my lord, if the nature and characteristic of the suit premises is changed, my lord, the entire suit of the plaintiff goes, my lord. It is rendered infructuous, my lord.
Where is that order of the learned single judge?
My lord, page 74, my.
Who has filed an appeal? The other side.
Yes, ma'am.
And then court has passed an order of stay.
Yes,
What has happened to the other side? Why the other side? Who is appearing for respondent?
my lord. Pilot service is not complete in regards to respondent 2 and 3, my lord. There's an office note, my lord, dated 5/5/2025.
SC GMC? You have given copy to the SCGMC.
Yes, my lord. My lord, they
Has
previously.
their names been reflected?
Yes, my lord. Yes, ma'am.
Yes, yes, Mr. Nayak.
Cancellation of.
In this case, item number 9,
Yes, Lordship. That cancellation of holding number matter, Lord.
no, there's some injunction order.
Yes.
What has happened to the appeal in the meantime?
My lord, appeal has been stayed, my lord.
Why?
My lord, why order of this honorable court?
Appeal can't be stayed.
My lord, my lord, appeal is not stayed, my lord, the order is stayed. Appeal
Huh?
is pending, my lord.
Operation of the interim order dated so and so in so and so by virtue of which trial court has been stayed is suspended. That's only stayed.
Yes, yes,
What has happened to the appeal?
pending, my lord.
What has happened? This has been going for the last 4 years.
Yes, yes.
Then how is it possible? This order was passed on 4/3/2021.
Yes.
Then if you have not been able to get your appeal, who is the person who has got the appeal decided? And your house is in the front setback.
Yes, ma'am.
You are in the front setback.
Yes.
Then, Mr. Nayak, kindly see page 69.
Lordship. It's a 337(3) and if you do not submit any explanation, notice, Lordship.
So this has been given to the owner.
Yes, Lordship.
Unauthorized construction over the front setback.
Yes, Lordship.
Now, being a tenant, he is taking the advantage out there.
Lordship. Yes.
Are you opposing or not?
Individual decision, one. Lordship, it is notice of 2019.
No, what he has done is this. The landlord, he's a tenant.
Lordship.
The landlord had given him a particular area which falls in the area which is in violation to the setback.
Lordship.
Okay. Now he comes and files a suit against the owner as well as you and gets an injunction before the trial court. Then an appeal is being filed by the other side. Other side?
Yes, yes, ma'am.
And that appeal is being filed. And in that appeal, the first day court stays it.
Yes.
Now, what is happening is because of he being in collusion with the owner,
Lordship.
it is being stayed for the last 4 years.
Lordship.
Appeal is not happening anywhere. Now, the other side is not interested in appearing, who has filed that appeal and got that order.
Yes, Lord. Stay order.
So now the problem is, you are not in a position to go ahead with this because of that.
One order is already operating. Yes, Lord.
So there the
Lordship,
problem.
I remember similar matter, Lordship. Your Lordship was prepared to impose cost upon the petitioner. Lord. Because ultimately it is the owner of the house who should have gone against this order. Lordship. Order
this
issued by the
Who
GMC.
is he?
My lord,
Is
If
no-
you are there in unauthorized construction of the front setback, then you have to go.
yes,
You
my lord.
cannot.
However, my lord, there is this, my lord, at page 73, there is a notification of the GMC, my lord, wherein, my lord, the defendants number 1 to 5, who are the co-owners, my lord, they have shown that the front side is clear, my lord, and they have obtained a building permission, my lord, for T+2, my lord.
Yes. But they are doing it. Filing the suit through him, not through them. Because they cannot file a suit against you.
Lordship.
Because of the bar under 337, they will require a declaration. Now, if it is a declaration, they have to give a notice. So what they do is they go for a permanent injunction. Now, can you have a permanent injunction
My lord, is-
alone
my lord, only
in a
regards to-
suit where you don't have your right? How can you have a permanent injunction? Tell me, how is it possible? Give me a good idea on how it is possible that
In
you
fact-
can
in
file a
fact-
suit for
In
permanent.
fact, their petition before the court below lordship, even not maintainable now.
Absolutely. That is what I am putting in. What is this permanent injunction business? You have been able to stay out there. Therefore, the other side is not appearing.
Yes, Lord. Probably they are in a collusion, lordship.
Absolutely.
One is helping the other.
How is a suit for permanent injunction maintainable without seeking a declaration to the effect that this notice is wrong? Tell me. That person concerned should have filed a writ petition or done whatever may be. But who are you? You have contested the case. Kindly see, Mr. Nayak, kindly see page 63.
Yes, before the court below lord. 18 objection.
First of all, you have to have a right over that property. What right do you have?
My lord, as tenants, my lord.
Huh?
My lord, only-
Tenant, what right do you have? Tenant of what? For all times to come.
No, no, my lord.
Then, देखो, heard Mr. So-and-so, the learned counsel appearing on behalf of the appellant petitioner. And Mr. P. Nayak, who appears on behalf of the respondent,
6 and 7, I think.
6 and 7. Pustak. None appears on behalf of the respondent numbers.
How nine is it?
No, it's okay.
1, 2, 3, 4, 5. Pustak. The supervisory jurisdiction of this court have been invoked, challenging the order dated 2/3/2021, passed in Miss Appeal number 9/2021, whereby the learned court of the additional district judge FTC number 3 Kamrup Metro at Guwahati, hereinafter referred to as the learned first appellate court, had stayed the operation of the order dated 1/2/2021 in exercise of the powers under Order 41 Rule 5 of the Code of Civil Procedure 1908.
Allegation to none?
To stop. This court have duly taken note of that pursuant that the petitioners herein are admittedly tenants of the respondent numbers 1 to 1 to 5.
Yes.
Full stop. A notice was issued by the Commissioner Guwahati Municipal Corporation on 25/5/2019 to the predecessor in interest of the respondent numbers 1 to 5, stating inter alia that there is an unauthorized construction over the front setback. Full stop. The petitioner's tenanted premises is located in the front setback. Full stop. The petitioner submitted a reply to the said communication petitioner submitted a reply to the said communication on 5/3/2019 to the commissioner, Guwahati Municipal Corporation. Full stop. Thereupon, the petitioner filed a suit seeking permanent injunction against against his landlords, their landlords, as well as the Guwahati Municipal Corporation, who were arraigned as the defendant number 6 and 7. First, the said suit was a suit for permanent injunction restraining the defendant numbers 6 and 7 from demolishing from taking any further steps in pursuance to the notice issued under section 337 of the Guwahati Municipal Corporation Act 1971. First, in the said suit, which was registered and numbered as title suit number 238/2019, an injunction application has been filed. Injunction application was filed, which was registered and numbered as
My lord,
Mizze case number 412/2019. Sticking ad interim injunction restraining the respondent numbers, the defendant number 6 and 7 from taking any further steps in pursuance to the notice it is also seen that pursuant to the filing of the written the suit as well as the injunction application, the respondents, the landlords had filed a written statement along with a counterclaim. Pustak. The respondents further, the landlords had also, who were the defendant numbers 1 to 5, had also filed their written objection the learned trial court, by an order dated 1/2/2021, granted an injunction in favor of the petitioners. Without specifying as to what injunction have been granted. Being agreed, the landlords, who were the defendant numbers 1 to 5, filed an appeal before the learned first appellate court, which was registered and numbered as Miss Appeal number 9/2021. Along with the said application, appeal, an application was filed under Order 41, Rule 5, seeking stay of the order dated 1/2/2021. The learned First Appellate Court, by an order dated 2/3/2021, stayed the operation of the order dated 1/2/2021 passed by the learned trial court. It is against that the present revision application has been filed. Present application has been filed by invoking the supervisory jurisdiction of the court. Full stop. This court, while hearing the learned counsels appearing on behalf of the parties, inquired with the learned counsel appearing on behalf of the petitioner as to what is the right of the petitioners over the scheduled premises, insofar as the notice issued under Section 337 of the Guwahati Municipal Corporation Act 1971. First, the learned counsel submits that he is a tenant, they are tenants, and as such have filed a suit for seeking permanent injunction. Full stop. This court finds it very relevant at this stage to take note of the judgment of the Supreme Court in the case of Sibdev Singh versus so-and-so, reported in 1993, 3 SCC page 161, and more particularly paragraph number 30, which specifically deals with suits of the present kind pertaining to unauthorized constructions. In terms with the said judgment, the Supreme Court had made it clear that for the purpose of ascertaining the prima facie case, for the purpose of granting an injunction, the plaintiff oblique the petitioners is not only required to show a prima facie case for going for trial, which will include the maintainability of the suit. In the instant case, it is the prima facie opinion of the court that the suit is not maintainable, since a declaration is being sought for insofar as the communication issued, notice issued under Section 337. Accordingly, in absence of a prima facie case, the learned trial court could not, which includes the question of maintainability, the learned trial court could not have passed the order dated 1/2/2021. Under such circumstances, this court finds no ground to interfere with the order dated 2/3/2021 passed in Miss Appeal number 9/2021. Accordingly, in that view of the matter, the instant petition stands dismissed. This court further directs the learned First Appellate Court to decide the said appeal, being Miss Appeal number 9/2021 at the earliest. And preferably within 2 months from the date of the instant order. The registry shall communicate the instant order to the learned trial court, First Appellate Court.
Just one line, Lordship. Subsequent to the notice, Lordship, one order was also issued on 3/9/2019, Lordship. This is 337(3). And that was challenged before the learned court below.
How can they challenge this without a
That's the
declaration?
same issue, Lordship. Lordship has
Why?
mentioned the notice.
Or at order at a notice as well as the order dated.
Obliged.
I disposed.
Item 18,
What is this?
Insurance company was challenging the quantum well, basically.
বাকি মেটার মধ্যে নাই নি? Hearing? কিসের নাম? You are challenging the quantum?
Quantum, my lord.
Yes, tell me.
But my lord, she had suffered with some facial injury, my lord.
Ah.
Now, my lord, the matter was earlier, my lord, remanded back once, my lord. And thereafter, my lord, the fresh award has been ordered, has been passed, my lord. That, my lord, in that, my lord, the compensation has been awarded of 25 lakhs 91.
Injury,
Injury, my lord. Injury case, my lord.
2006.
My lord. My lord, again, my lord, the matter was remanded back, my lord, the judgment was then delivered in 2018, my lord.
15, 18.
18, my lord. That is under challenge.
You have been given 25 lakhs.
25 lakhs.
You have for the insurance company?
Insurance company. I'm for the insurance company.
Insurance company. Okay, then
My lord, the
what is the injury?
injury was, there was facial injury, my lord.
What
She-
happened?
My lord, she suffered some facial injury, my lord. Then, my lord, against that, my lord.
Young
on the
girl
loss of
sustained
amenities, my
facial,
lord,
her face has been damaged, thus her structure is at stake on the amenity claimant is entitled to 10 lakhs. What? 7 lakhs. Then? How did he come into this 10 lakh business?
Exactly. That is,
How?
Some photographs has been.
No, no, understood
Yes.
very well. Isn't it required that there should be
It is required,
reasons?
my lord, it is not been written in so many words, but ultimately considering the matter in its entirety,
Okay, what is your evidence? Let us see.
the evidence will clarify, my lord.
some photographs were, my lord, exhibited, my lord, that, my lord, exhibit 72 to 75, my lord. The subsequent, my lord, after the matter was remanded back.
Photographs at page 90 of the records, my lord. Exhibit. That additional evidence was given pursuant to the leave granted by this honorable court.
Page 90 was the earlier photograph.
Prior and subsequent, next is the after accidental.
Okay, now what has happened?
The total face has been deformed, my lord. And still the person requires constant medical supervision. Still she requires medical supervision. And one of the ground taken is that the father was an employee of IOC, so it was reimbursed. To that extent, lordship may kindly peruse page 54 of the record, my lord. It's a communication issued by IOCL dated 11/11/2008. So all the expenses incurred in Gangaram Hospital, they have rejected, madam.
Ah.
One of the ground is taken that since amount has been reimbursed, the claimant is not entitled. Lordship may kindly see what amount has not been reimbursed, my lord. Well, Lordship will find at page 80 of the record. It was placed before the tribunal. With all the supporting exhibits, my lord. Page 80.
7 lakhs.
Lordship, that was 7,41,000.
Hmm.
That was the amount awarded by the learned tribunal, my lord.
This was rejected.
It was rejected, my lord.
Then
And as regards future, my lord, expenses,
Hmm.
5 lakhs was granted. And as regard amenities, my lord, also took into account the future expenses which was there, my lord, in page 80. The projected future expenses was 50 lakhs, my lord, 15 lakhs.
Hmm.
Entire face has been deformed, my lord.
Huh?
The face has been totally deformed.
Now what is it?
And the disability certificate was also exhibited.
There.
It's at page number 77, exhibit 42. Which says, my lord, nature of disability LD 30%, visual 40%.
Where page?
Page 77, my lord, of the records. Exhibit 42. And this disability caused due to the accident only.
What is this left? The nature of disability is?
LD and visual.
What is LD? She see with her both her eyes.
The visual 40%
What is the present state of hers?
present is still requires, but as per my specific instruction.
Huh.
That presently also requires medical requires medication, and that is been done in Gangaram Hospital only in Delhi.
No, no, এইখন ক'ত গ'ল এইখন? আৰু এটা আইয়ে আছিল নেকি চাওঁ? There's a stay?
Hello?
There's a stay
Is a statement.
complete?
But because, this.
5 lakhs was granted, my lord, that has been withdrawn at the time of admission.
Yes, my lord, I was engaged later on in this case, but I'm not. Position.
Okay, 5 lakhs.
5 lakhs withdraw করেছে।
What is wrong with these judges? Like, the accident.
Lordship, earlier it was dismissed because there was some discrepancy. That order will find that Lordship, page number 108 of the record. That before, once it was dismissed by the tribunal, subsequently appeal has been preferred.
Why it was dismissed?
The tribunal found some discrepancy in the accident information report regarding the date. Subsequently by this order, my lord. A copy to the
Then
Then, my lord, this order, my lord, of this honorable court. It was remanded back and the claimant was allowed to adduce additional evidence. The expenses which were incurred after dismissal.
so thereafter, what evidence you gave?
Additional evidence was given, my lord. That additional evidence for
Who gave?
the father, claimant, CW1 is the father.
For the evidence, Thaneswar Barua.
Thaneswar Barua, my lord. And he was cross-examined. That cross-examination, lordship will find it page 103 of the record.
medical evidence is given.
Medical evidence exactly not given, my lord, all other documents has been, the list of exhibits possibly found that, with the deposition of, with the evidence of CW ones.
Subsequently, you gave evidence of the medical bills.
Yes, my lord.
Three bills, my lord,
Three bills.
67, 66, 67, 68 exhibits, my lord. Those are of, my lord, 2009 and 14, my lord.
E-ticket, car fare, photograph and medical bills, 66, 67, 60. Those amounts which were reimbursed, it was specifically written as paid to company. That those documents were also exhibited. And the tribunal has not taken into account those medical expenses.
You are not on appeal.
I'm not an appeal. No, that is what meant. Only those which has not been reimbursed, that has been paid.
Discharge. This is Gangaram.
What's it?
The patient admitted with complaint of distress mentally inability of.
Gangaram at page 18, page 19, undergone surgery, my lord. On page 42, undergone surgery. Page 44 also there.
What is the present status? It's a long matter now.
My instruction is that she is still required medical supervision. Now she is developing breathing
No,
problems.
instruction is not evidence. Is instruction evidence?
Not my lord.
Then what is LD?
LD, learning disability, it says that it will, may I read, my lord? Will you let me put? the context of disability, LD stands for learning disability. It refers to a group of neurodevelopmental disorders that can affect a person's ability to learn and use certain skills such as reading, writing, speaking, and math. Learning disabilities are not related to intelligence or motivation. They are neurological differences that can impact how the brain proceeds information.
Yes, Mr. So what do you have to say?
The future Milord medical
No,
expense.
we have to complete this matter. Means the question is, here, yes, the trial court did not do it properly, but that doesn't mean.
So far as the medical expense are concerned, that subsequently, which was whatever was produced before the exhibited, those are of 2009 and only one document of 2014, where about 1,29,000 was spent, if I'm not wrong. Exhibit 68, but the exhibit 66 and 67, this evidence was reduced in 2017. This additional evidence. Now, there, some documents of the last one document of 2014 and others of 2009, which were exhibited. So far as treatment after this.
He has given that year for medical expenses for 7,41,000.
Given that,
Huh?
that has been allowed.
Ah.
So that has been allowed. Mainly.
Pain and agony, 2 lakhs.
Right.
Traveling expenses, 1 lakh.
Right.
Cost of attendant, 50,000. Future treatment, 5 lakhs.
The future treatment, as far as future treatment is concerned, with this photographs, these are not duly proven, and we do not know at which stage these photographs are taken, whether at the initial stage of the treatment or
You didn't put an objection.
that. is
When
of
these
course-
were exhibited, you didn't put an objection.
It's true, but then those documents were not duly exhibited. There was no the certificate of with regard to those photographs.
What?
The electronic evidence, but photographs, they were not properly.
You should have objected it. There's
That's
no objection.
That's true, man.
Well, we are not going to go into that.
True, man. Not,
Now, can we enhance it?
but only 10 lakhs has been given with regard to the
It's too less, no?
But we don't know what's
Don't worry, with these papers, I'll enhance it. And you have not given it for such a long time, so we make it around 20 here. Remain entries, so it will be around 35 lakhs, 91,000.
So far as the evidences are
Because
concerned.
this is 168. 168 is reasonable. A person's having lost her face, a girl having lost her face. Where is the question of marriage proposal and all these things are not there? These are other phases. That she lose her marriage proposals and all these things. which
On
are-
all these accounts, this 10 lakhs was awarded.
No, loss of amenities.
Amenities.
That is too less.
Amenities would also come up with that.
She will not get married. Until now must be, she was 26 then, 2005,
2005, she was, at the time of accident, she was 19.
19.
Yes.
Today, 20 years gone. And she didn't get the relief at that point of time, which makes it therefore more incumbent upon this court to enhance it.
That of course, when it was
Ah.
remanded by this honorable court.
No, there's no remanding back. So
It's
we
because-
say that she should get 35 lakhs plus interest at the rate of 9%. For 6%, they have given 2 less.
Though, this not a fetter, but the claim was for around 19 lakhs, this honorable court granted 21 lakhs, 25 lakhs. Though, of course, that is of course not a, lordship can always determine just compensation, that cannot be But then.
There's
then
one
you-
judgment of the Supreme Court I still remember. In fact, I used that judgment in another matter pertaining to, what's the name of that case? There, what has happened, there was no counterclaim
Yes,
filed by the other
yes,
side.
yes.
And then I used that, taking into account the similar provision of the Land Acquisition Act, wherein the Supreme Constitution Bench, Supreme Court categorically says that it is not the question of a person how much he may ask for. Some Mahetri or something, M starts with an M. Anyway, so there the Supreme Court says the person may ask for more
Yes.
or person may ask for less.
Less, well,
But what is required to be given is the just and fair.
that's true, I'm not, that's not. That's
So
just,
not on that.
true, that is there.
That citation is
That-
Lordship 2003 2 SCC 274 regarding MSCP.
That can be done, that.
That-
There is a Constitution Bench judgment.
The
on that.
lottery feel just, my lottery can award.
So that was some other case. But anyways, what is this you are challenging unnecessarily?
Because this,
You should have given this money and finished it off then.
this came to me much more when the council was appearing, there was no more. But came to me later.
We dismiss your appeal. Heard Mr. M. Dr. the learned counsel appearing on behalf of the appellant. Mr. So appears on behalf of the respondent number.
Number 1 and 2. 1 and 2.
On number, why the daughter is not here?
It was filed for the father. of the man.
She was a major then.
At that time, she was major. All the expenses were borne by the father.
Well, maybe, but it is yeah, 1 and 2. And the payment will be made to the bank account of that lady, the girl, not to your father, mother.
Daughter.
It's an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 5/1/2018, passed by the learned member Motor Accidents Claims Tribunal, Tinsukia, in MACT case number 107/2006. The ground of objection taken in the instant appeal is that the learned tribunal have awarded the said amount, have made an award in favor of the claimants which is not based upon evidence. And Mr. M. Dr. the learned counsel appearing on behalf of the appellant further submitted that in terms with section 168 of the Motor Vehicles Act 1988, what a claimant would be entitled to would be the just and fair compensation, but not a compensation which has no reasonable basis. Full stop. The learned counsel therefore submitted that this is a case where the learned tribunal have awarded an amount which is not fair or reasonable, for which interference is required. So stop taking into account the said ground of objection which pertains to the quantum arrived at by the learned tribunal, this court finds it relevant to take note of the facts which led to the filing of the instant appeal. On 24/8/2004, at around 11:30 AM, while the daughter of the claimants, Srimati Sikha Moni Borua, was proceeding in a rickshaw with her friend Banti Sunar, full stop. Suddenly, one truck bearing number AS 01.
ASE, ASE 6981.
What is the number?
ASE 6981.
ASE.
Yes.
Oh, that's so old. ASE 6981. Being driven in a rash and negligent manner, knocked down the rickshaw on the 80 road near Sweet India Hotel, which resulted in the daughter of the claimant suffering severe injuries on her face and other body parts. Pustu. Subsequently, immediately, the daughter of the claimants was admitted to the civil hospital, Tinsukia, but due to seriousness, she was shifted to Aditya Nursing Home, Dibrugarh. Thereupon, she was referred to Sir Gangaram Hospital, Delhi, where she received her treatment. Immediately upon the accident, immediately after the accident, a case was also registered, being titled Tinsukia PS case number 355/04 under section 279/338 of the Indian Penal Code against the driver of the offending vehicle. It is pertinent to mention that at that relevant point of time, when the accident happened, the daughter of the claimant was studying was a student of BA. Full stop. The claimants sought for a compensation of rupees 19,78,797. Full stop. Pursuant thereto, the appellant herein, who was the opposite party number 3 in the claim proceedings, filed its written statement, wherein various pleas wherein various general defenses were taken. It was also stated that the claim was without any basis and excessive, and as such liable to be dismissed. The owner of the offending truck also filed a written statement wherein have denied the claim on the ground of being vague, incomplete, and did not contain all material particulars. The fact that the truck in question was insured with the appellant insurance company is not in doubt, inasmuch as during the period when the accident, at the time when the accident had taken place, the truck in question was insured with the appellant insurance company, which was valid from 22/1/2004 to 21/1/2005. On the basis of the pleadings, the learned tribunal framed 3 issues. Which are herein under. At this stage, it is relevant to take note of that pursuant to the issues being framed, evidence was adduced, and the learned tribunal, by a judgment and order dated
17/11/2009.
17/11/2009, dismissed the said claim petition on the ground that there was certain doubt as to the date of the accident. Being aggrieved, the claimants preferred an appeal before this court, which was registered and numbered as MAC Appeal number 121/2011. The coordinate bench of this court, by an order dated 30/7/2017, after duly taking into account the documentary evidence came to a opinion that the learned tribunal had erred in law in dismissing the said claim proceedings. So accordingly, this court, the coordinate bench of this court, by then order dated 30/5/2017, set aside the order judgment and award dated 17/11/2009, and remitted the matter back to the learned tribunal for a fresh decision, thereby allowing the parties to adduce further evidence for enabling the tribunal to determine the just and reasonable compensation. The record reveals that pursuant thereto, the claimant, number one, had submitted a further evidence stating inter alia, further evidence on 8th of September 2017, stating inter alia that the daughter of the claimants continued to suffer on account of the said accident, and he had to incur further amount of rupees 5 lakhs for the treatment of the daughter. It was also mentioned in his evidence that in the meantime, there were two more major operations carried out and it was also mentioned that there are two more major operations to be carried out in the month of October 2017 at Sir Gangaram Hospital. It was further mentioned that on account of the accident and consequent injuries in her face, in the face of the daughter of the claimant, face, head, legs, shoulder, and other parts of the body of the daughter of the claimant, the daughter of the claimant along with the family members were suffering. This court further takes note of that in the said evidence, additional evidence, the claimant have also placed before the court photographs of their daughter prior to the accident and post the accident. The claimant number one was cross-examined. Wherein it was mentioned, wherein the claimant number one stated that an amount of around 6 to 7 lakhs have been reimbursed by the Oil India Limited. And apart from that, the claimant number one had also incurred a lot of money. He further denied that he had quoted an exaggerated amount of rupees 5 lakhs. No further evidence was adduced by the appellant company. The learned tribunal thereupon decided the appeal by the impugned judgment and award dated 5/1/2018 and granted a compensation of rupees 25,91,271 along with interest at the rate of 6% per annum from the date of filing of the claim petition till realization. Full stop. In the backdrop of the above, the question therefore arises as to whether the learned tribunal was justified, was justified in arriving at the conclusion that the just and fair compensation was rupees 25,91,271. Full stop. This court have duly taken note of the arguments made by the learned counsel appearing on behalf of the appellants as well as the counsel appearing on behalf of the claimants. Full stop. This court further have duly taken note of the evidence which have been placed on record, including the fact that the child of the girl, the daughter of the claimants, continue to suffer as on date on account of the accident which had happened in the year 2 decades ago. Full stop. The fact that this court have also duly taken note of the discharge certificates which have been issued by Sir Gangaram Hospital, which have been duly exhibited before the learned tribunal. And from the said, it appears that there has been continuous reconstruction of a face being done, which had to be done on account of the accident. Full stop. Considering the above, it is also seen that a fit girl now has the fit girl was having a disability of 30% VD,
30%
LD, and 40% VI,
40% vision.
VI,
Yes.
VI. Full stop. Considering the above, full stop, this court is also aware of the fact that the compensation which is to be awarded on account of loss of amenities cannot be mathematically arrived at on account of loss of amenities cannot be with mathematical precision. It has to be on the basis of the sufferings which have caused to the daughter of the plaintiff of the claimants. Full stop. In the opinion of the court, upon perusal of the materials on record, the amount of rupees 10 lakhs which have been awarded by the learned tribunal on account of the loss of amenities cannot be said to be on a higher side. Full stop. On account of the medical expenses, it is seen that the claimants have duly proved that this amount of rupees 7,41,271 have not been paid to the have not been reimbursed by the Oil India Limited. Full stop. This court have also taken note on account of the pain and agony, traveling expenses and the cost of the attendance which have been awarded do not seem to be on a higher side. This court further takes note of from the evidence of the claimant witness number 1 that it has been stated that for future treatment, another amount of rupees 5 lakhs was necessary, taking into account the certain other two major operations to be done in the month of October 2017. Full stop. There's no cross-examination in that regard by the respondents. Full stop. Taking into account the above, this court do not find any ground for interfering with the compensation so claimed, the compensation so awarded by the learned tribunal. Full stop. Full stop. Absolutely. tribunal to the tune of rupees 25,91,271. Mr. M. Dutta, the learned counsel for the appellant, however, submitted that taking into account that there has been a delay in the proceedings on account of the fact that on the earlier occasion by the judgment and award dated I go to 2009 dated so and so, the claim proceedings was dismissed, and thereupon the claim proceedings was again restored by an order dated 30/5/2017. He therefore submitted that during this period, the appellant insurance company should not be penalized on account of the interest. This court have also given an anxious consideration that during this period, from hey, their judgment to 17/11/2009 till a to date to the 35. So there is no fault on the part of the appellant insurance company. First, accordingly, this court is of the opinion that the claimant would be entitled to the interest on the compensation so awarded with effect from the date of filing of the claim proceedings till awarded to the 17/11, or what is that, 2009?
17/11/2009.
17,
this
till 17/11/2009. The claimant shall not be entitled to interest from 18/11/2009 to 35/2017. However, after 35/2017 till date, till realization, the claimant would be entitled to interest as awarded by the learned tribunal. Full stop. This court further, accordingly, the instant petition appeal stands disposed of with the following observations and directions. Number one, the amount awarded by the learned tribunal to Namtu Dirivu in MSC case number so and so to the tune of rupees 25,91,271 is a just and fair compensation. And as such, the question of interference with the said award, says the said quantum arrived at, does not arise. Number two, the claimant herein would be entitled to interest with effect from the date of filing of the claim proceedings till 17/11/2009. For the period from 18/11/2009 to 35/2017, there shall be no interest. However, with effect from 31st
of July.
31/5/2017 till the date of actual deposit of the entire amount, the claimant would be entitled to interest. The interest so awarded by the learned tribunal, being 6%, is also considered to be just and reasonable. The appellant insurance company is directed to deposit the amount along with the interest as mentioned herein above before the learned tribunal within 6 weeks from today. Number 8, the amount which have already been deposited before the learned tribunal, before this registry, shall be deducted shall be duly deducted.
Apply.
At last, something has happened.
I'm the plaintiff decree holder. And there was a lease agreement, my lord. But this opposite party did not hand over possession of the suit premises and did not complete the construction and did not hand over the suit premises. So I filed suit. Suit was decreed. I filed execution proceeding. Well, there they have taken a plea that the period of tenancy has already expired. So the plea has become non-inexecutable. the learned has also dismissed my execution proceeding value on the ground that the decree cannot be executed as the term period of tenancy has already expired.
Where's the decree?
My lord,
You are the tenant?
I'm the tenant.
Then
And property was not handed over to me. But the agreement was for construction of a premises and to deliver possession.
Hmm.
They neither constructed the premises nor delivered the possession. So I filed the suit for completion of construction and delivery of possession of the suit premises. It was decreed. Then I filed execution proceeding. Now there they have taken the plea that the agreement was for 5 years, it has already expired, so decree has become inexecutable.
wait,
So my lord, my this
decree
execution
that
proceeding
the
was
defendant do
rejected.
hand over the possession of the suit premises to the plaintiff. And the plaintiff shall occupy the same as tenant in accordance with the terms and conditions of the agreement of tenancy.
Right.
Detailed below. So this was given in 2015.
My lord,
What is the date of the agreement?
agreement, my lord, 1/7/2009.
1/7/2009, and the decree was given after 6 years. Then also the court gave it. Now they filed an application under 47,
My lord,
stating that it was dismissed. And accordingly, your ER was dismissed.
my lord.
Where is the tenancy agreement?
It is exhibit 1. I can pass it, my lord, the original agreement here, my lord.
What is this misappeal file?
This appeal, my lord, against this dismissal of this execution proceeding, misappeal was filed, and it was held that misappeal is not maintainable. And after that, my lord, this revision petition.
Now, did they complete the work? Huh?
My lord, so far my plaintiff is concerned, they have not completed the contract.
So then how can they be handing over to you? If they have not completed the work, Because your plaint is to that effect, that he has not completed the work.
Completed the.
Now, has he completed the work? Your cause of action will only arise then after it is completed.
To take instruction in the meantime, what is happening?
That is why I fixed the matter after long, long time. Don't you remember?
My lord,
Then 19/3/2025, I have fixed it on 19/5/2025.
my lord.
Then
My lord, I contacted him and he said that he is sick, so
the
cannot come. my lord.
agreement, I have asked you to file an affidavit
Affidavit, yes,
bringing on
he could
record the
not come, my
agreement.
lord, but he informed me that he is sick, my lord. So
Huh?
I
He's not
informed this-
interested.
I have informed him, my lord, he said that he is sick, he cannot come.
This court, by an order dated 19/3/2025, directed the petitioner to bring on record the agreement dated 1/7/2009 by way of an affidavit. Full stop. The said affidavit has not been filed. It is also seen from the records, more particularly the copy of the plaint, that the allegations made therein is that although the petitioner paid an amount of rupees 2 lakhs to the defendant for construction of the premises, but the defendant have not constructed the premises. Thus, under such circumstances, a question arises as to whether the execution proceedings is at all maintainable without there being a constructed premises wherein a tenancy can come into existence. Because as the counsel, as the petitioner have failed to file the affidavit, comma, it, this court grants a further time for the ends of justice to the petitioner to file an affidavit. First, list this matter again on 18th of August 2025. If it is made observed that if no affidavit is filed on or before the next date, comma, it would be deemed that the petitioner have lost interest in the instant proceedings.
Item 3.
Yes, what is this?
My lord, they say, sir, I am the plaintiff decree holder. My suit was decreed. And during the pendency of the suit, defendant number 1 died. And that fact was not brought to the notice of the court or not to the plaintiff.
You are the plaintiff.
I am the plaintiff. Thereafter, when the execution case was started, they filed a petition under section 47 that the execution case is not maintainable. Because during the pendency of the suit, the original defendant number 1 died. We have
The
contested
decree is a
that.
nullity. Decree is a nullity.
My lord, what happened is this, my lord, there are two defendants, two defendants. One died during the pendency of the suit, and his
Who
wife
died?
was still there,
Huh?
and the wife filed a written statement also.
Where is the plaint?
Place 1-4.
Who is 1/1?
1-1 is the wife.
She was there earlier.
Yes,
How come? Why 1/1, not 1/2? Not
she was subsequently impleted.
Huh?
He was subsequently impleted in the suit.
So you got the decree.
Yes,
But you did not amend your plaint.
and there's
You
no-
did not amend your plaint. Okay.
it was not amended because the it was amended on 10/4/1984. Rate for amendment base is 8.
Here it is being given to the defendants. The decree is against the defendants.
Yes,
Now, the wife was there.
I was there at that time.
Their wife also died
I also died.
during the pendency of the
My
suit.
wife also died, the, after the date of.
On
uh,
14/9/2005,
14,
9/2005.
2005. And when was the decree passed?
2001.
14/9/2005.
The wife died,
So the wife was there.
wife was there,
Then,
but they did not amend the plain, as your lordship has observed,
no. But the decree was passed. At that point of time, the wife was alive.
Right.
wife was alive.
So when did Abdul Hai die?
Dulhai died on
25/6/2000.
25/6/2000.
Huh?
25/6/2000.
25/6/2000. Okay. And wife died on
14/9/2005.
2005. Decree passed on 29/11/2001. Isn't it?
Yes,
Okay. Now, who was representing both?
the sons and daughters of defendant number 1.
Hmm? Where's the impugn order?
Lordship, it starts from page 78. The other legal heirs of dependent number 1 ought to have been implemented. Rather substitute.
The death certificate was issued on 18/11/2014.
In fact, there are 2 death certificates, Lordship. That is why the doctor who, issued that certificate, she was examined.
Which are the 2 death certificates?
Sure.
One is on 28/9 and 13/9.
39/2.
So she will see, find it at page 82. The official witness, namely Dr. Anjali Bordloy Roy, examined as PW1, deposed that she has appeared before the court along with documents as described in the summons. Exhibit 1 is the copy of the summons. Exhibit 2, which is a death certificate, was issued by their office. The death certificate is one of Abdul.
Mr. Sharma, there is one judgment of the Supreme Court which it says when the wife was present, here the estate is duly represented. If the estate is duly represented, it would not, because one is there. The others may have a right to be. Others may have a right, but the fact that the wife have duly represented the estate. I think 1964-65, there is one judgment of the where the question arose before the Supreme Court was very specific. It's a very interesting case where a person concerned, all the legal representatives were not there. Would it abate? The Supreme Court said no, it would not be a nullity or it would not abate because the estate is duly being represented. A different thing, they can very well come up and say that, look here, I am also entitled. Now, this person's concerned, who is the lawyer, had duly even signed out there in the Wakalatnama, everything he had even signed in the decree.
Agree.
Where is the judgment? No homework.
Well, then
Done that.
I have another judgment. Madam.
Ah, fantastic. Tell me.
Shiva Shankara others versus HP.
Supreme Court,
Yes, Supreme Court.
what is the name?
Shiva Shankara. Shiva Shankara and another versus HP. Yes, sir. Veda Yashab sir. DR Gabhai and C.T. Ravi Kumar.
Two 2019, 3 SSC 520. It is following the earlier judgment. Is that the judgment?
Yes.
2019.
23. This judgment is of 23. This judgment is of 23.
What is the, you say, what is the citation?
Live law. 2023 live law SC 261.
Name of the parties?
Shiv Shankara, SHIV, SHANKARA.
Huh?
Shiv Shankara and another
Spelling properly.
SHIV
SHIV.
SHANKARA.
Shiv Sankara. SHANKARA. Impleadment of all legal heirs of the deceased in the appellant when known as held. If out of all the living, a majority of them are already on record, they contest the case on merits, it is not necessary to bring other legal representatives on record for the reason that the estate and the interest of the deceased devolved on the legal representative is sufficiently represented by those who are already on record. So they have not also exercised the duty under Order 22 Rule 10A.
Yes, notice.
Then in that regard, what was the stage of the suit at that point of time? When he died? 26, 25, 6. 25. Mr. Sharma, you have a big problem with this suit. The case was transferred back to some other court. Now, this is pursuant to some orders being passed. Plaintiff till date, till today, take no steps and today filed a petition praying for direction for deposit the survey cost as per the order of the Honorable High Court. The High Court at the rear directed this here. This court have nothing to do with the petition filed by the plaintiff. It is the duty of the plaintiff to take proper steps. As such, as the last chance is given to take steps unless the suit will be dismissed. Plaintiff had not taken steps. Both sides present, plaintiff to submit.
But the survey was done, you also can see, look
No,
to,
what has happened is this. There was an order passed in some second appeal of 91. In the order of the High Court dated 6/1/97 in appellate decree number 89 sent memo dated so-and-so Honorable Court by the order dated dismiss the essay and as also ordered that the stay order shall be vacated. Accordingly, inform both sides. 5/12/1998 for steps. Matter goes on, no steps, no steps, no steps, no steps, no steps.
judgment of the trial court. It is stated that after remand directing the courts below for getting the suit land. Accordingly, land was surveyed by ASO, Palijan Circle, who has submitted a report in accordance with the rate issued by this court. Page 27.
No, what has happened is trial court passed the judgment. Okay,
Yes.
against that, an appeal was preferred by the defendants in 86. The district judge remanded the matter back to the civil judge for making a survey. Against that, there's a second appeal file. I think it's an essay. The essay was dismissed by the High Court on 6/1/1997. Thereupon, the matter went back to the trial court. Nothing. And the court passed the judgment on 29/11/2001.
The survey was done. Survey was done, page 27.
Understood, survey, everything is done. But after that, defendants were not there. So after 1997, the defendants were put not to any notice. Therefore, there were specific directions issued to take steps. Steps were not taken. This is the record.
Well, they filed Hazira, advocate filed Hazira on. At the advocate for the defendant filed,
Then why the order sheet says something else? That is what I am saying.
Record, no? Page number 18 of record. you will see.
No, kindly see these. See these orders. 1998 it has come. Both sides are absent. Badi Vaya Hazin Nai. Hazin Nai. Badi PO and transfer.
17/4/2000 your lordship, kindly.
Huh?
17/4/2000.
Plaintiff side absent without step. Defendant side present. And these people somebody. Peruse the case record, it appears no notice has been served to the parties. As such, above notice to both the parties fixed 17/4/2000 for report. Then, Dajjo Iman Bihar Hukum. No, defendant side absent, plaintiff present, defend learning counsel for the Iman for steps. Learned counsel for the plaintiff present through steps. Then there is a direction to take steps. Steps. The defendant therefore always remains on two successive occasions. Earlier also did they appear? Peruse the case where plaintiff is present through advocate, no report since, reminder sent so and so plaintiff to take steps. While Hazira seen earlier orders, it is seen that since about 2 years, no report has arrived in spite of filing a writ of amendment so and so. Plaintiff shall take steps. Defendant side is absent without steps. Learned counsel for the AI is to present to Hazira notice of so and so. Then now what to do?
On 17/4/2000.
And majority, there are many. Majority are not here. Only one is here.
17/4/2000, dependent present, and 11/4/2001, dependent filed Hazira.
So you knew about the suit. Obviously, you can't say. Then why didn't you go for it? What is that judgment?
As your lordship had said, the majority of the legal heirs should have knowledge of the fact. There are 7 numbers of legal heirs here. Only the wife was present.
No, why didn't you inform? The lawyer's duty it was, no?
Yes.
Then?
Then, because of the fault of the lawyer, the party should not suffer. The finding has been recorded to that effect. The finding has been recorded to that effect by the learned court below.
Then?
So therefore, this decree cannot be executed.
Further, regarding the contention of the decree order that so and so engaged of the mayor, Abdul Hai did not inform the court about the death of the Abdul Hai and even signed the decree. The court is of the legal heirs of the deceased should not suffer for failure of the engaged counsel to inform the court about the death of Ia. What is that judgment?
Shiva Shankar and Anand.
Shiva,
Shiv Shankar and Anand.
if you have not produced it, I'll dismiss it on the ground that majority are not there. Chalo, we dismiss it. You can't help it. Heard Mr. S.C. Sharma, the learned counsel appearing on behalf of the petitioner. Senior counsel appearing on behalf of the petitioner, assisted by so-and-so and Mr. P. Bhumik, the learned counsel appearing on behalf of the respondent. The jurisdiction under section, the revisional jurisdiction under section 115 of the Code of Civil Procedure 1908 have been invoked to challenge the order dated 28/2027 passed in Miss S. X number 38/2018, whereby the application under section 47 of the Code of Civil Procedure filed by the respondents herein was allowed, holding inter alia that the execution proceedings could not be proceeded with, could not be maintained in as much as the decree, judgment and decree dated 29/11/2001 was in title suit number 45/78 was passed against the defendant, who was already dead on 25/6/2000. Full stop. This court have duly taken note of the submission made by Mr. A.C. Sharma, the learned senior counsel, to the effect that although the defendant had expired, defendant Mohammed Abdul Hai had expired on 25/6/2000, but then also his estate was duly represented by his wife, who was the defendant number 1/1. Full stop. Mr. P. Bhumik, the learned counsel, submits that a perusal of the execution proceedings, execution application so filed, which is enclosed as Annexure 5 to the instant application, would show that the defendant number 1, Abdul Hai, not only had his wife, but 6 other legal representatives, which is an admitted fact. Full stop. The learned counsel submitted that the Supreme Court, in the case of Vijay A. Mittal versus Kulwant Rai, reported in 2019 3 SCC 520, submitted, observed that implement of all the legal heirs of the deceased defendant is not required when out of all the legal representatives, majority of them are already there on record. He therefore submitted that in the instant case, merely because the wife of the defendant number one was implemented as the defendant number one bracket small one, but as it is an admitted fact, as would be seen from the very execution application, that there were there were 6 legal representatives, comma, the six, comma, the decree so passed insofar as the defendant number one is concerned cannot be proceeded with. First, this court have duly considered the submissions made by the learned counsels appearing on behalf of the parties and have also perused the materials on record. It is seen from the materials on record that initially the title suit number 45/1978 was decreed by the learned trial court, that is the court of the civil judge, court of the Munsif at Gwalpara. The defendants who are the defendants in the said suit being aggrieved had preferred an appeal being title appeal number 85/86 before the court of the district judge Gwalpara. The learned court of the district judge Gwalpara, by an order dated 28/2000/1988, had remanded the suit back to the learned court of learned court of the civil judge junior division number 2 Gwalpara, and directing for a survey of the suit land. Full. Being aggrieved with the order of remand, the plaintiffs had filed an appeal before this court, which was registered and numbered as SA number 37/1989. This court, by an order dated 6/1/1997, had dismissed the appeal and thereby directed the learned trial court to proceed with the suit by going ahead by carrying out a survey of the suit land. This court further takes note of that in the instant proceedings, further have taken note of the records of the title suit number 45/1978, which was called for by this court. From a perusal of the said record, it does not reveal that the counsel who was representing the appellant, the respondents, had appeared before the learned trial court post the remand. It is further seen that subsequent date.
Post remand they appeared.
No, that is not there. It is further seen that on 29/11/2001, the learned trial court had decreed the suit in favor of the plaintiff. It is very decreed the suit in favor of the plaintiff. It is also seen from the order dated 23/11/2001, only the plaintiff was represented and not the defendants. Now, in the instant case, it is an admitted fact that the defendant number one had expired on 25/6/2001. However, the respondents concerned However, only the defendant number one's wife was there, was arrayed as a party to the said suit. Full stop. There were 6 other legal representatives of the defendant number one. Full stop. Which is an admitted fact, as would be seen from Annexure 5. Full stop. This court finds it now relevant to take note of the judgment of the Supreme Court referred to by the learned counsel appearing on behalf of the respondents. The learned referred to the judgment of the Supreme Court in the case of Vijay A. Mittal, Supra, and full stop, Supra. Paragraph 23 to 26 of the said judgment duly taken note of the judgment of the Supreme Court. Vijay Kumar Mittal, wherein the Supreme Court observed that if out of all the legal representatives, majority of them are already on record and they contest the case on merits, it is not necessary to bring other legal representatives on record for the reason that the estate and the interests of the deceased devolved on the legal representative is sufficiently represented by those who are already on record. Full stop. In the instant case, the records of the title suit number 45/98/78 shows both the defendant number 1 and defendant number 1A had filed separate written statements, isn't it? Separate written statement. Full stop. Considering the above, comma, it is therefore the opinion of this court that the learned trial court could not have proceeded with the execution proceedings. Being title execution case, the learned trial court was justified in not in passing the impugned order as regards not to proceed with title execution case number 12/2013. Full stop. Be that as it may, this court, however, finds it relevant to take note of that the learned trial court, while passing the said order, impugned order dated 28/2022, did not take into consideration as to whether the execution proceedings can be proceeded against the legal representatives of the defendant number 1A who expired only after the judgment and decree passed by the learned trial court. Full stop. Considering the above, this court therefore revives the execution proceedings being mis-execution case number 38/2018 insofar as and revives and directs the learned executing court, that is the court of the Munsif number 2, Gwalpara, to proceed with the to adjudicate as to whether the suit can proceed against the legal representatives of the defendant number 11 who had filed a separate written statement. Full stop. Considering the above, this court therefore partly allows the instant application, thereby restoring mis-execution case number, title execution or mis-execution? Title execution case number 12/2013 to the court of the learned Munsif number 2, Walpara, full stop, and further directs with the following observations and directions. Number one, the title execution case number 12/2013 is restored to the file of the court of the learned Munsif number 1, Munsif number 2, Gwalpara. Number two, the execution proceedings insofar as the defendant number 1 is concerned stands abated. Number two. However, number three, the proceeding insofar as the defendant number 1A is concerned, however, is not abated. And the learned executing court shall determine as to whether the execution can proceed against the legal representatives of the defendant number 1A who expired subsequently.
If it recorded the date of death of the defendant number 1 as 25/6/2001, it should be 2000.
2000 only. 2000, no? 25/6/2000. I remanded it to that extent to see because they had filed two different written statements. So I have a look at it. At last, whatever may be, you should not unsettle a decree. And I think you should, taking into account this order, you should file an application before that. The lawyer did not inform. Something is to be done.
Hello.
Item 4.
Records returned, huh? And I'm fixing a date for appearance of both the parties on 1st of July 2025 before the trial court.
1st of
July. Yes, what is this?
We have filed that, it's in Annexure 8.
Huh?
The
What are you
order-
challenging?
the Order that bit was missing, of 30/11/2023.
No, madam, what are you challenging?
Just that, written statement shouldn't come in this, summary suit. That's all. So written statement has 30 days and leave to defend is only 10 days. And written statement is not a prevalent practice when it comes to summary suit.
Hmm.
And we have already submitted our evidence as well. So since our evidence stage was also done, it should have been heard and decided.
Where your friend, other side?
He was supposed to come. He did say he was going to come.
Hmm? Hello, we have it on some other day. Ms. A. Soikia appears on behalf of the petitioner. Post.
This matter is
It
actually
is
almost.
further seen that pursuant to the order passed by this court on 21/4/2025, the petitioner has filed an affidavit bringing on record the orders passed in Mize case number 496/2023. So taking into account that the respondent is not represented today, this court for the end of justice adjourns the matter This matter again on 4th of June 2025. It is observed that if the respondent is not represented on the next day, the proceeding shall be, this court shall proceed with the instant proceeding in its absence, in the absence,
Five.
in his absence. Yes, what is this?
Yes, my lord. Plaintiff, my lord, filed a petition, my lord, seeking, my lord, seeking, my lord, to file, my lord, evidence in chief of 4 persons, my lord. 2 is my, their paternal uncle, 1 is maternal uncle and Daugura, my lord. That has
What?
been rejected, my lord.
Praying to allowing the plaintiff to file evidence in chief of form of affidavit of her paternal and so. It is averred that the plaintiff instituted the suit for granting of a decree that she being the daughter of so and so. Defendant side so and so.
Order is case number 72 and operative court from pending, my lord.
Yes, what is this?
Yes, my lord. My lord, the said application was filed on, my lord, when the, my lord, cross-examination of applicant witnesses was closed, my lord.
Of whose?
The plaintiffs, my lord.
Plaintiff. Defendant has evidence.
Not studied on the date of, my lord, completion of the plaintiff evidence, my lord,
Then you file this.
on the same date, my lord,
Okay. Then
on, my lord, but that has been rejected, my lord.
that has been rejected. You are
Dated-
going to bring this witness by yourself? No summons?
Evidence in chief.
Are you going to file the evidence on affidavit of these witnesses by yourself? Or is it an evidence by which you are going to seek their presence to the court?
They will present before the court, my lord.
Mr. Counsel, are you aware of the difference between Order 16 Rule 1 and Order 16 Rule 1A? Are you aware of that? Are you aware or not? Counsel appearing on behalf of the petitioner doesn't seem to be aware with the provisions of law. He therefore seeks for an accommodation. Mr. So and so submits that he has, the petitioner is enjoying an interim order, thereby delaying the disposal of the suit.
Next week, my lord.
Considering the above, this matter again on 4th of June 2025 for admission. So stop. Interim order passed earlier shall continue till then. Read that provision, then come over.
Item 6.
What is this?
Lordship is judgment when order dated 22 page number 16, Lordship.
Oh, what has happened? The other side is not appearing?
Not appearing, Lordship, service completed, Justice of Judge.
Why? You are the wife or the husband?
My husband, Lordship.
Okay.
Service completed. But not appear, Lord.
Now you are paying 8,000?
12,000, Lordship.
Huh?
12,000. Section 125. Yeah. I challenge the order, section 24, ASM, Hindu Marriage Act, Lordship. Page number 16, relevant portion 20, Lordship. Intemporary is allowed. By this provision.
So you are paying already 12,000
12,000, Lord.
earlier.
Early.
Are you? He is also a constable.
The constable, sufficient income, Lordship. Therefore, I challenge the order. Section 24,
You have paid the litigation expenses?
already paid, 30,000.
File an
But,
affidavit?
But 8,000 not paid,
Huh?
as per this honorable court order.
The interim order is there as regards the 8,000. File an affidavit that you are
Already
paying
filed,
you have paid the litigation expenses and what you are actually paying today. Huh? We'll have it next day and finish it off. Release the matter again on 6th of June 2025. In the meantime, the petitioner herein shall bring on record what the petitioner is actually paying as on date, paying, and what the petitioner have already paid.
Item 7, hearing under order 41, rule 11 CPC.
Lordship, along with this RSA Lordship and another appeal was preferred Lordship. That has not been listed today, Lordship.
Chal.
And as per office note dated Lordship. And as per office note dated, the address has not been found, Lordship.
Not necessary. List this appeal at the stage of order 41, rule 11, comma. As the said appeal is directed to, no, it is seen, it is seen that the appeal is yet to be admitted by formulating a substantial question of law. Considering the above, the appeal be listed at the stage of order 41, rule 11. This court further observes that the service upon the question of service upon the respondents shall only be considered after admission of if any substantial question is formulated in the instant. This is appeal on 9th of June.
Stay matter item 21.
Yes, what is this?
Lordship, in landlord tenant matters, there are similar other matters, Lordship.
Huh?
There are similar other matters also, Lordship, which are pending.
What is this matter?
It's a landlord tenant matter, Lordship.
Landlord tenant, go
I am-
court.
Concurrent finding by the expert, although it is ex parte, but.
Huh?
The plea which they have taken that because of the absence, this order has been passed, judgment has come to be passed ex parte, that is not sustainable. Because appellate court has dealt with that matter. And there is a concurrent finding return.
What is your ground?
That has been treated with your lordship kindly, page number 56. There are 14, 15 and 16.
Is an ex parte judgment
Yes, ma'am.
Yes, Lord.
when in the appeal.
Lordship, the date was missed and the council was not present and it went ex parte. Lordship.
The appeal, what happened?
In the appeal, a detailed.
You have raised all the points.
Page 56, para 13, my lord.
Eight,
Page 56, para 13.
during the hearing, the appeal being argued. The action was partially decreed in favor of the king. What happened?
At the stage of framing of the issues, I filed a petition. The plaintiff has filed a petition for striking down of some pleadings under order rule 16. And on that day, the next day was fixed for furnishing of the copy. Even on the next day, they did not appear. On the first day, when this petition was filed, it is admittedly the suit was kept on hold against. But they have the very much the knowledge about the filing of the missed case, which has filed for striking down of the pleading. Even then, they did not appear. And most importantly, Your Lordship, when the CRP was filed, in the CRP, this plea was taken by the plaintiff petitioner, who was put on caveat that in spite of filing that of the petition, a written statement, they did not appear. And even in the High Court also in the CRP, on some occasions, they have failed to appear. In spite of their name showing in the police. So this suit was totally conducted in a very careless manner. And they're putting the blame on the plaintiff that behind their back, this proceeding was taken, and this judgment of decree and judgment came to be passed. This is not sustainable. This, at para 16, it has been, clear finding has been written by the appellate court.
Also, there are 5 shops which are under
Out of
adjudication
that, 3
now.
has been decreed.
3 has been decreed, and all the 3 are under challenge before this court, Lordship.
This is the third.
This is the third one, Lordship. Only in this case, the dates were missed by the
That is
council in
not
the,
the
before the trial court, Lordship. Otherwise, all the 3 cases, we have been undertaking it diligently, Lordship. Only in this case, somehow the dates were missed, it went ex parte, Lordship. And in the similar case, Lordship, your Lordship has only held
Cases,
similar cases, Lordship.
pendencies,
Similar
other
parties-
cases has no relevancy with this.
Other cases are what?
Similar case, Lordship.
In the
Similar
same party.
shop number 10, 11. This is shop number 11. Those are shop number 10, shop number 9. Same parties, Lordship, same problem, same tenant eviction decreed. It has been decreed.
So
And
are
we
you
have
saying
challenged
that
that-
you are paying, you are not a defaulter?
Lordship, the
I'm
rent,
asking you, see, he has gone on the question of a defaulter. Are you a defaulter or not?
no, Lordship, we were paying rent, Lordship.
How?
What the court below has written up.
How?
Lordship, there was no systematic format of paying rent, Lordship. They used to collect in a lump sum manner or in sometimes in that manner we were paying the rents.
Why
And
did you
thereafter-
file an appeal?
What?
Why didn't you go on order 9, rule 13? The moment you go on the order 9,
In
section
fact, they filed it, my
96,
lord.
you give up your right in so far as non-hearing proceeding ex parte. Then how do I help you? I have all intentions to help you, but how do I help?
They have in fact filed it and withdrawn. Then thereafter, they have in fact filed under order 9, rule 13. That was withdrawn and they have subsequently this was filed. And this was also, appeal was also filed belatedly with condemnation petition.
Hello, we do one thing. Execution you have filed?
Execution is put on hold. That is because of the pendency of the appeal. Thereafter, they have preferred the revision, so we have not went ahead.
Lordship, my only submission is to hear all the matters together,
But
Lordship. One matter has been
Other,
admitted by the,
there are
Other matters
two
are
more
different, my
matters.
lord.
yes, Lordship,
All I have been held to be defaulter.
No, my lord. Out of 5, 3,
3.
DP has been passed in 3. In all the 3 cases,
We have
concurrent
filed-
finding has been returned.
We have filed revisions in. all.
Defaulter.
Separate set of evidence has been laid. Although it is between the same party, this,
Same.
that the plea which my learned friend is
Have
taking,
you
that will
filed
not help
written
us.
statement or not?
In this case, yes.
Written statement
Only
was filed.
we have filed it.
Show me your written statement. What is your name?
Yes, 25.
Page 25 is the statement.
From 78 you are there.
Yes, Lord.
When are you vacating?
Decree was passed in 16/5/15. Their appeal was disposed of on 5/8/24.
Okay, when are you vacating? Hello, not today. Let us not be so harsh today. Let us
Lordship,
have
in
it on which day.
One similar matter and rent was enhanced by this honorable court and we are paying that in the court.
Which one?
In one similar matter, in this party is only, Lordship, another CRP.
It's not here.
Yes, that is
Oh,
there.
Today it is not listed.
Today-
that I
not
did it
listed.
for applying Atmaram. I
Yes,
remember
Lordship.
that one.
This,
Ah,
Another. This is the, of your
It's
lordship.
okay, that is different. That I stayed it only subject to that.
yes, Lordship.
That
And
was almost 2 years back,
Yes, this is of
2022.
5/8/22. 5
another
at 20.
revision in 20.
22, 23, 24, 25. I thought that matter would
The
be.
revision has been admitted. That is pending.
That-
But nowadays I have got a very shortcut mode of dismissing this type of petitions. At that time, I was new as a judge, so I didn't have that.
Lordship, the same.
Not necessary. I'm not looking into all this. Okay, when should I dismiss it? Give me a good date. When? Okay. Why 125? 24. Third of June, 2025, 2 p.m. Dismissal. Take your instruction whether you want to be there for 6 months or not.
22,
Right, Lordship.
Yes, who is going to where?
Lordship, from Udalguri to Morigaon,
Huh?
Udalguri to Morigaon, why?
Udalguri to Morigaon. Udalguri is there, Morigaon is there. You are, what do you do?
Wife does nothing.
Huh?
He was a housewife before.
Lordship, I am file affidavit, Lordship, in one.
What?
I will file affidavit, Lordship, one week time can be given, Lordship.
Absolutely no.
Yes,
I gave you last time.
Yes, sir.
Then don't keep on asking this type of
Lordship,
thing.
due to my physical illness.
We filed by 34.
Due to my physical illness.
Okay, 1 lakh cost, we give him 1 lakh cost. 1 lakh cost. You want time, I can
Doctor-
give you time.
Doctor will
25,000 cost.
Doctor will certify Lordship, he, with respondent cannot do.
What?
Rani, Lordship.
Huh?
Doctor will certify Lordship, if respondent
Is
cannot just
she working or not? Is she working or not? No. How will she go there? Are you paying her something every month?
If he file a maintenance case, will file. Lordship.
No, no. Are you paying her something? Transfer. You file your
Okay, file
affidavit
one
also.
time.
Transferred on. You will appear on 27th of June. At where do you want?
Morigaon.
Morigaon. Morigaon. You will file his written statement there. Allowed.
23,
My written statement was not accepted because of 39 days delay. Against that, I am before your Lordship, madam.
Yes.
Page 47, para 6 of
Mirzapur ka isme. Hello?
Cost.
No cost. This is
Because
not a case
2
of
years.
cost. No, I normally impose a cost, but this is not a case of cost. There is a reason why. First of all, the trial court made a mistake. One is filing a written statement and one is filing a counterclaim. Counterclaim, you cannot stop till you frame the issues. Isn't it? Isn't it the law? You have not framed issues. Then how can the trial court stop him from filing the counterclaim?
The written statement doesn't accept.
So what? Is it
Without
required?
pleadings, without defense,
Is it required?
without defense, written statement.
Not be there. In addition to. The word uses in addition to the defense. Order 8,
Yes.
rule 6A.
6A. A defendant in a suit may, in addition to his right of pleading
Isn't it?
against the claim of
In
pleading.
addition to his right of pleading, which is a written statement, can file a written counterclaim.
So in addition, if there is no written
And
statement,
therefore the word used here is not later than. You see that?
yes. By your counterclaim against the claim of the plaintiff, any right or claim in respect of a cause of action accruing to the defendant against the plaintiff, either before or after the filing of the suit, but before the defendant has delivered his defense.
Defense. Now what has happened is this. the Supreme Court says this right continues till the framing of issues. This is Arun Mishra's judgment, isn't it? Therefore, this is, although I'm also of the opinion that, but now the Supreme Court makes it that you can file till the issues of no cost. We can impose the cost upon the lawyer, he's a SBI lawyer, so use cost. Mr. KK will pay you 25,000.
That petition was pending since 2022 and it was disposed over 2024 only.
Which one?
Their petition. Since 22 to 2024.
No, this one is just very new.
Yes, it was disposed on 26/9/2024 in impugned order.
Which one?
Impugned order. Page 45. And there, the application was pending since 11/8/2022.
Oh, 26/9. You filed it very delayedly, huh? Date of filing is when? What is the date of filing that people write on? Filing date ko na থাকে এখন এখন কি মানে e-filing 7 March. You filed delayed. Oh. 25. 20,000. Let us impose a cost of 20,000. Looks fair. Look, heard Mr. KK Day, the learned counsel appearing on behalf of the petitioner. Mr. S.D. Purkayastha appears on behalf of the respondent, no?
Respondent.
Respondent.
Others, yes.
The petitioner herein has respondent number 1.
One loss.
The petitioner herein has approached this court challenging an order dated 26/9/2024, passed in title suit number 73/2022, whereby the learned court of the civil judge, junior division number 1, Kachar Silchar, had rejected have refused to accept the written statement which was filed on the ground that the written statement counterclaim was filed 39 days from the expiration of 90 days as mandated under Order 8, Rule 1 of the Code. Full stop. This court have duly taken note of the application and the reasons so assigned, which resulted in the delay in filing the application under order, filing the written statement. Full stop. This court further takes note of the judgment of the Supreme Court in the case of, what is the name of the judge? Some Ashok something, na? What is the name? This court further takes note of the settled position of law that the counterclaim can be filed within prior to the issues being framed. So, taking into account the above, it is the opinion of this court that the learned trial court by the impugned order dated 26/9/2024 ought not to have rejected the counterclaim so filed by the petitioner. Full stop. This court further is of the opinion, taking into account the grounds and reasons so assigned, that the learned trial court ought to have also exercised its jurisdiction under section 148 of the code and thereby granted some additional time, taking into account that the written statement was already brought on record, counterclaim was already brought on record. Full stop. This court further is of the opinion that the written statement as well as the counterclaim being substantive rights the same, has to give way to the procedural laws. Accordingly, this court interferes with the order, deems it proper to interfere with the order dated 26/9/2024. Next, this court also is of the opinion that there has been certain delay in this court is also opinion that that the action on the part of the petitioner also shows lack of diligence as well as negligence, in as much as the impugn order was passed on 26/9/2024, and the petitioner has approached this court on 7/3/2025. First, this delay in approaching this court have delayed the further disposal of the suit. First, considering the above, it is the opinion of this court that some cost have to be imposed upon the petitioners so that the plaintiff, who is the respondent number one herein, can be compensated. First, accordingly, the instant petition stands disposed of with the following observations and directions. The impugned order dated 26/9/2024, passed in title suit number 73/2022, is interfered with. Number two, the petitioner herein is permitted, given the number two, the interim order passed by this court on 12/3/2025 is vacated, and the parties herein are directed to appear before the learned trial court on
Next date is 36.
36/3/2025. Full stop. Number three, this court directs the learned trial court to accept the written statement cum counterclaim filed by the petitioners. Full stop. However, now full stop. Next, subject to, the petitioner herein is imposed the cost of rupees 25,000, which the petitioner has to deposit before the learned trial court on 30/6/2025. Full stop. Number four, the petitioner herein, the learned trial court is directed to accept the written statement subject to the deposit of rupees 25,000 as directed herein above. Number five, full stop. The deposit of rupees 25,000 shall be a condition precedence for acceptance of the written statement cum counterclaim. Number six, the plaintiff is given the liberty to file an application before the learned trial court for release of the said amount, and the learned trial court shall pass appropriate orders. Number seven, the learned trial court, upon acceptance of the written statement cum counterclaim, shall provide due opportunity to the plaintiff to file additional written statement.
For orders, item 8.
Oh, yes. So this court have duly taken note of the affidavit filed by the learned counsel appearing, who learned counsel Mr. K.A. Mujumdar,
Along with my junior.
wherein it is duly stated that the appellant number one had expired and no steps have been taken by the appellant. He further submits that the appellant also had prior to his the appellant number one, prior to his death, also took back the records. Full stop. It is seen, when did it happen?
That was in the lordship, subsequently I came to know he died, lordship. As per respondent lordship, but it was perhaps in 2012, lordship, I could not remember the date, lordship.
This
Because
court
he has-
have duly taken note of that on 3/8/2015, it is duly recorded that the appellant number 1 had expired. No, 17. (22/4/2015), it was informed that the appellant number 1 has expired. Full stop. However, no steps have been taken. Taking into account the above, it appears that the appellant, the legal representatives of the appellant, appellant number 1 has expired, but no steps have been taken. Full stop. The appellant number 2 is also, have not also engaged any person after the file had been taken. It therefore appears that the appellants are not interested to pursue with the instant appeal, for which the instant appeal stands dismissed for non-prosecution.
10,
Second step. Second step, manner.
Okay, we vacate the interim order. It is seen that the steps have not been taken by the counsel appearing on behalf of the petitioner. In spite of opportunity being given on 19/3/2025. From the above, it therefore appears that the petitioner have lost interest in the instant proceedings. Full stop. Considering the above, it is seen that in spite of the order being vacated, the interim order being vacated on 19/3/2025, the petitioner have not taken steps upon the respondent numbers 1, 2, and 3 as directed by the order dated 19/3/2025. From the above, it therefore appears that the petitioner is not interested in the further proceedings of the instant proceeding. For further proceeding, what is this? To proceed further with the instant matter. Full stop. It is also seen that the supervisory jurisdiction of this court have been invoked against an injunction order, isn't it? Then an injunction order. Full stop. If the petitioners are not interested to further proceed, this court would not like to further, would not like to exercise its supervisory jurisdiction against the impugned order, for which the instant petition stands dismissed.
11,
Service complete?
I'm appearing for a respond number 1.
What is the review we are seeking?
The page.
Huh?
It is 81, my lord.
What have I done wrong?
No, nothing wrong, my lord.
When?
It's only the part, my lord, if your lordship may come to page 84, my lord. Nothing wrong, my lord. But if your lordship may come to page 84, my lord.
Ah.
Of the judgment. Is it- If I may. be that is maybe, the court is of the opinion that it is in the repetition, there was an order passed on so and so, thereby staying the order dated 19/8/11 until further orders, and the said order continued all throughout till today. The impugn communication dated 6/1/2009 should be applied prospectively to the petitioner's school from the date of the instant judgment. And here, Malad, we are seeking seeking liberty to assess the ESI contribution from 2016, where there is a finding of the honorable court by the coordinate bench, to which this writ petition has been disposed. Well, only that part, Malad, we are seeking to,
Where?
Malad, at para 4, my lord, of the.
Para?
Para 4, page 83, Malad.
Then,
Malad,
why you are saying about 2016?
Malad, this, the writ petition was disposed of, Malad, in compliance with the, in direction with the, this court orders, it is where your lordship will find it page 72, Malad.
70?
72, Malad. And Malad, the operative portion, at page 80, Malad. And for here, Malad, if I may, Malad, the last, fourth paragraph. However, since the operation of the impugn notification was dated by this court, it should be applied prospectively to the education institution, and no school should be forced to subjugate themselves retrospectively under the ESI. It is its order thus. Here, Malad, there, Malad, the liberty was given to the corporation to access ESI contribution from 2016, Malad.
Where?
Malad, by this order, Malad.
It never said so. Where you say so?
Malad, here, Malad.
You file your objection? And so admits that you would like to file his affidavit in the matter. List the matter again on 23rd of June 2025. Yes, anything else? Huh?
Same today. Item 12.
Is everybody, service not complete? It's complete?
I'm appearing for respondent 3.
3A.
3A.
He could deliver summons only upon 3A. He refused to receive summons on behalf of the others.
Who are you?
And for respondent 3A,
Who is 3A?
he is the
Son.
legal heirs of respondent
Son.
3. Son.
3A is the of,
The deceased defendant. Defendant number 3.
Dependent number 3.
and who is 3B to 3L?
Other son and daughter side.
All are sons, but they are asserting separate.
Huh?
They are asserting separate. I am not representing. We are not representing.
So are you happy with this, there being a stay? What is your case?
Amendment pair was rejected.
So why you are delaying it? Who is the defendant?
Defendant number 1 and 2 are the subsequent purchasers.
Subsequent
They are the
purchasers.
seller. Defendant number 3 who died. And the sale deed which they have
So
notified.
your specific performance is against them.
No, right suit for right title interest. So they sale deed, which they are, defendant number 1 and 2 are saying that they had purchased from defendant number 3. We did not know about that sale deed. We came to know about that sale deed from the written statement. So we simply want to incorporate that part. The sale deed, which we did not know. That
We are delaying.
Defendant number 1 and 2 have filed their return statements and. we
Hello,
agreed with
you do one thing. You take service by Dusty.
my lord. And registered post also, my lord. And also registered post.
Huh?
And also registered post also, my lord.
The service upon the respondent number 3B to 3F being not complete, the petitioner is directed to take fresh steps by way of Dusty, routed through the registry of this court, and file an affidavit of service on or before the next date so fixed herein below. Full stop. List this matter again on 16th of June 2025. Full stop. Interim order passed earlier shall continue till next date.
I live.
And anybody? What is this?
My lord, here, my lord, service is complete, my friend APS, my lord.
What is the matter about?
Malab matter here, Malab, that amendment was allowed. Malab the court, learned court below was of the opinion that the sufficient pleadings are there. These are mere repetition. So in that view of the matter, Malab, I have challenged on the point, Malab, that whether power under order 6, rule 17 could be exercised for restating or Malab, repeating the available pleadings, Malab. This is the Malab otherwise case. And some judgments also there, Malab, just to aid or subtract the pleadings to give a higher, bigger meaning or to ends of justice, my lord, the amendment can be allowed, not for restating what is already there. My lord, the impugn order itself says that so far the amendments are concerned, sought for, there are already sufficient meaning. Is this a mere repetition? So therefore, we have challenged that matter.
You have challenged the amendment.
Yes.
Service complete?
There is same, my lord, that's why.
Continued. my lord.
Okay, list this matter again on. List this matter in the stay column on. 19, no, on 23rd May 2025. In the stay matters column, and so interim order passed earlier shall continue. What is the prayer for recalling of the order? What is wrong?
Yes, Lordship, item number 16, Lordship. Lordship, in this case, Lordship, I have filed an application for delay petition, IA. And in that petition, when the petition is pending, Lordship, two respondent was expired, Lordship. I have filed for substitution. And on that day, when I withdraw the substitution petition, inadvertently the delay of petition also dismissed, Lordship. Delay petition was also dismissed.
Correction kori diyo.
Item number 16. There is delay for 489 days for in RSA, Lordship. I'm
Yet order nine. Yet I
293. Public 25.
TC does appearing on behalf of the applicant submits that he will withdraw the instant and as such he would not like to press for filing an application, explaining the delay in preparing the application for substitution of the legal representative as well as so and so. Then IA4 council has would not like to pursue the instant accordingly in the name of so and so struck off. What do you want to withdraw?
Lordship, I want to withdraw the IA number 3657.
3657 is for what?
3657 for restoration.
No,
for
for application under Iman praying for subsidy of the legal heirs of the
I am
deceased, respond number 3 and 4.
the deceased respondent number 3 and 4. When I pray for Lordship that I have not perused, not
Are struck off. So
Yes,
they are struck off.
struck off. And
The council is given a year. So this is allowed. Now on that day, this order was passed.
Yes, Lordship, in
Okay.
IA number 212.
Heard Mr. So and so. You are appearing? Appearing on behalf of so and so, Mr. Assistant City appears on behalf of the respondent. This is an application for recall of the order passed on 21/2025 in ISC 212/2020, whereby this court had closed the said interlocutory application on withdrawal. Pusto, the learned counsel appearing on behalf of the applicant submit that that this order was passed inadvertently inasmuch as there was no such prayer in that regard. Mr. R.C. Sansati,
R.K. Jain.
Huh?
I am R.K. Jain. Not Sancheti, I am R.K. Jain.
oh, I am sorry. Mr. R.K. Jain, who was appearing on behalf of the respondent, also does not oppose this. Pusto, taking into account the above as it is an inadvertent mistake committed by this court, comma, the order dated 21/2025 passed in ISC IAC 212/2020 is recalled. And IAC Civil 212/2020 is restored to the file of this court. First, IA stands allowed. Assistant sitting in RKJ, huh? Anything more?
Lordship, in item number 19, there is an interim which needs to be.
Item number 19, where?
Hearing
FAO.
column, my lord.
Hearing. Item number 19, list this matter again on. Where there?
My lord, in connected matter 20, my lord, I'm on instruction, I'm appealing today, my lord, contempt matter. In this matter, my lord, 2 weeks may be granted to file my response, my lord.
Okay, at 20 Lepo, Mr.
As Dr.
S. Doctor appearing on behalf of the respond number,
Well, all the.
on behalf of all the respondents, would submit an affidavit in opposition in the instant contempt proceedings. He therefore seeks for 2 weeks' time in that regard. List this contempt proceedings on 25/6/2025.
26, 20.
25/6. Stop. Itu লিখিব আৰু এইটো FAO টো লিখিব list this appeal on 25/6/2025. Stop. The interim order passed earlier shall continue till then.
File your place.
Anything more? Only 2 matters.
Item number 13.
13, 14. What is the review?
Lordship, a small modification is spread for my lord in this.
Sure.
Order is dated, my lord. 5/3/25.
What do I do?
Lordship, actually, it's my wrong submission, my lord. Lordship, will see, page 14, para 7, my lord. MHA appeal, my lord.
Para 7.
Yes.
That in the event the appeal is allowed, the appellant herein would be permitted to recover the same from the owner.
Lordship, here, Lordship, para number 6, my lord, the claimant is.
On such depositment,
to-
the claimant would be at liberty to file appropriate application before the
The
registry
registry.
for release and the CR. Yes, then?
Lordship, the issue is that, my lord, the accident took place post amendment, my lord. And there is no, that provision of recovery has been omitted, my lord.
That I'm not there. That I'm going to dismiss you of all these petitions. I am therefore said, nah, in the circumstance, I am going to allow your appeal. Then I'm going to allow you to recover it from the owner. There are six judgments of different high courts.
For simple observation, modification, my lord, that claimant will furnish undertaking, my lord, that much.
Claimant has no business.
Yes, that is why, my lord, because the owner is to pay.
Owner, no, you are going to pay,
I'm going to pay, my lord. If
but
I-
you can recover it from the owner.
That is the issue, my lord, because this appeal
Uh.
out of the accident dated after the amendment, my lord. That after the amendment, that provision of recovery has been omitted, my lord.
Understood, but the there are 6 high courts which have held that it is permissible. I can give you 6 high courts. Every high court is allowing it. Will be at the next one. I've asked these MACT matters to be listed next week. This week, I'm going to take up a lot of MACT matters. One of these is this, my point of attention.
Want to clear, my lord, that they will furnish some bond, my lord,
Ooh,
payment while withdrawing the amount, my lord, from the registry.
claimant has no business. Your question is, you are challenging what?
That permit violation of.
Amount of rupees remand along
Amount
with
is small,
interest of
amount is
remand. Well, this is the amount for, he was hurt. What is the ground of appeal?
There was no permit, my lord, in this,
Huh?
the vehicle had no permit.
No, why such a small amount is given?
Lordship, the.
It's a debt,
No injury case. ma'am. Simple
injury case.
simple.
So what is he going to do? If he gives a bond, what is he going to, he'll return it to you.
No, Lordship, if the amount is withdrawn by the claimant,
Ah.
and if we, even in the event of succeeding the appeal,
Ah.
we have to recover it from the owner, man.
I've said that I will pass a direction. If you win the case, I'll pass a direction. This is my wording. I've made it very clear.
Only apprehension before, for filing this application, my lord, for your lordship, that recovery provision has been omitted. That is my
Understood,
apprehension.
but that is the reason why. You see, that is your ground. So I've asked you to deposit. Tomorrow, if you win the case, then obviously I will allow you to recover. Then court will give a direction allowing you to recover. That is why I said that. You see, that is the reason why. So what to do? Dismiss this. This is an application, this is a review filed seeking a direction. It's a review file. The instant application, this is an application seeking review of the order dated 5/3/2025, passed in ISC number 6154/2025. Mr. T. Gulta, appearing on behalf of the applicant, submits that the review has been filed, taking into account that the provision of section 149.
Put it in subsection for proviso, ma'am.
Huh?
Section 149, subsection 4. Proviso.
The review application has been filed, taking into account that after the Motor Vehicle Act 1988 having been amended with effect from 1/4/2022, there is no provision for pay or recovery. He therefore submits that if this order is not reviewed, the applicant would not be in a position to recover. Full stop. This court is of the opinion that as in the order dated 5/3/2025, it has been duly mentioned that the payment is directed to be made by the applicant, and in the circumstance the applicant is successful in the said appeal, the appropriate directions would be issued for the purpose of recovery to be made from the owner, this court finds no ground for reviewing the order dated 5/3/2025 in IS Civil number 614/2015. Full stop. I stands closed. Review petition stands closed. Anything more? One more? No more? Huh? Itu. Huh? Yes, I think. Return of the notice in line with the
MSC approval. Respond number 3 and 4 has received the notice.
Why I'm asking you to make the payment, there is one reason. This matter gets fast. Once you make the payment, they will come and then get hold of them. Bas.